Be ready for the dictation. 5 seconds to go. Sir, it had been further argued on behalf of the defendants that under Section 34 of the Specific Relief Act, the plaintiffs must have direct interest and entitlement over the property for which the declaration is sought. Section 34 of the Specific Relief Act states discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may, in its discretion, make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. In the present case, the plaintiffs are not seeking a declaration that they have a beneficial interest. A derivative action is sought only for the beneficial interest of the second defendant. The second defendant has, however, abjured such interest. Whether such disclaimer or abjuration is the result or effect of collusion or fraud are further aspects to be examined. Such abjuration has to be weighed with the flow of funds through the second defendant to the first defendant, leading to the allotment of shares to the third to the seventh defendants. Examining all these aspects can only be through advancing oral and documentary evidence. This would further imply that the suit has to be retained on file. It had been further contended that the suit relief is barred under Section 187C of the Companies Act 1956. It had been contended that primarily the third, fourth, and seventh defendants should first make a declaration that though the shares are in their names, a beneficial interest had accrued to the second defendant. Similarly, the second defendant has to make a declaration that they are the beneficial interest holders of the said shares. It has been contended that in the absence of the above declarations, seeking a declaration against the first defendant would be akin to putting the cart before the horse. I hold that the declarations made or not made in the books of the first defendant would be to the exclusive knowledge of others. In this context, the 8th to 10th defendants have a vital role to play. Evidence is necessary from their end to disclose facts and to subject themselves to cross-examination on all these aspects. The plaintiffs have pleaded the facts to their knowledge. It must also be kept in mind that except the third defendant, no other defendant had sworn to an affidavit. Questions raised by the plaintiffs remain unanswered, and trial is the answer to determine the actual facts. I hold the plaintiffs cannot be non-suited at the threshold. The suit is only at its early stage